I qualified Donald Trump for the ballot, but under Maine law, any registered voter can bring a challenge. And that's in fact what happened. There were 3 challenges. One of those challenges was brought by 2 former Republican state senators and a former Democratic state senator. And I was required by the law to hold a hearing within 5 days and then to issue a decision 5 days after the hearing is closed, which happened when all the parties had submitted all of their briefs to me. So this is something that I did not choose to do, but that I was obligated to do under Maine law and the Constitution. Mindful that no Secretary of State has ever deprived a candidate of ballot access under Section 3 of the 14th Amendment, but no presidential candidate has ever engaged in an insurrection under Section 3 of the 14th Amendment. My job was to evaluate the facts presented at the hearing, the evidence that was produced, and the record created in that proceeding, and to evaluate that and make a ruling, which is what I did. The weight of the evidence made clear that Mr. Trump was aware of the tinder laid by his multi-month efforts to delegitimize the 2020 election results. And he then chose to light a match. This is not a criminal matter, and Section 3 of the 14th Amendment does not require a conviction. That definitely makes it a more complex and close question, as I acknowledged in my decision. It was not a close call on the question of whether January 6th, 2021 was an insurrection. The events of January 6th, 2021 were unprecedented and tragic. They were an attack not only upon the Capitol, government officials, but an attack on the rule of law. And the evidence presented at the hearing demonstrated that those events occurred at the behest of and with the knowledge and support of the outgoing president, Mr. Trump. The oath I swore to uphold the Constitution means that my only consideration can be the Constitution and Maine election law.
I'm Nick Riccardi, a national political reporter with the Associated Press based in Denver, Colorado. And tonight we have another blockbuster ruling on whether former President Donald Trump can continue to run for his old job. The Secretary of State in Maine, a Democrat, ruled that he cannot because he violated the 14th Amendment's prohibition on those who engage in insurrection from holding office during January 6th, when there was an attack on the U.S. Capitol. This was the first time in history an election official ruled that that measure, which was added after the Civil War, would prevent someone from running for the presidency. And it comes 1 week after the Colorado Supreme Court issued a very similar ruling saying that Trump wasn't eligible to be on the Colorado ballot. Now, to be clear, he remains on the ballot in Colorado and Maine. Both the Maine Secretary of State and the Colorado Supreme Court have stayed their decisions until the case gets appealed. And it's the U.S. Supreme Court that's going to make the final decision on whether Trump can stay on the ballot in those 2 cases, and indeed all the other states in the nation. They've never before ruled on this measure. They've never before ruled on whether it applies to Trump. and whether it would prevent him from being president again.